the amount that you're stating. Well, I don't want him to go there because that's also in the definition of a foreclosure consultant. And if he had gone in that direction and started justifying his offer based on what he believed the property value was or would be when he would go to sell it, he would automatically become a foreclosure consultant and he couldn't purchase the property. So the investor needs to be taught. And like I said earlier, one of the definitions of a foreclosure consultant and a service and agreement is an oral statement to the seller. And you need to be very, very careful now of what you say to someone. So I handled the situation by turning it around and asking the seller, well, did this person who advised you, did they enter into a foreclosure consulting agreement with you and give you all the written documentation to prove to you that that is what your property is worth? And he goes, no. And I said, well, that's what the law is. And he goes, oh, I remember seeing something about that, and we got a letter from the banking commission about that. And I said, so we can't answer that question. And we're not going to even attempt to answer that question. The only thing that we want to tell you is that this is the contract, this is what the offer is, and we need to know whether you want to accept it or not.
This brings us to common PHIFA myth number 3. If you tell a homeowner what you think the property is worth, you are a foreclosure consultant. Again, this is a myth, and this statement is false. If you remember earlier when we looked at the definition of a foreclosure consultant, you should remember that nowhere in there did it talk about whether or not you disclosed to a homeowner what you thought the property was worth. As a foreclosure consultant, however, if you do due diligence regarding the value of the property, then the law does require you to disclose that due diligence to the homeowner.
And this is why, I said, this is why the investor needs to be trained as to what questions he does not want to answer. And normally what I tell my investors is, I will go out with you and you're not allowed to speak. This way I know they can't get into trouble.
And finally, this brings us to common PHIFA myth number 4. An unlicensed foreclosure consultant can work for the buyer without the buyer being a foreclosure consultant. Again, this is a myth and the statement is false. We have several issues here that we need to deal with. First is, the foreclosure consultant you've been listening to advertises and functions and represents himself or herself as a foreclosure consultant, and as such, any time a buyer hires this individual, that buyer also becomes a foreclosure consultant and is prohibited by law from purchasing a residence in default or a residence in foreclosure. Now, how do we know this? We know this because of a landmark case named Johnson v. Wheeler, and we're going to discuss that case right now. Johnson v. Wheeler is actually a relatively complicated case, but it's a landmark case regarding the Protection of Homeowners and Foreclosure Act. This case was actually in the federal court, federal district court for the state of Maryland. And in this case, there were several different players, but a couple of the players was a Mr. Shepard, who was the mortgage broker, Mr. Wheeler, who was a real estate broker, and the Johnsons, who were the sellers, and the Jacksons, who were the buyers. And as you can see in the part that I've got highlighted right here, and there's 18 pages of very small print as far as the opinions of the court, but what really pertains here is the part that I have highlighted here. It says, similarly, according to the Johnsons, Wheeler represented that he would stop, enjoin, or delay the foreclosure sale, save their residents from foreclosure, and arrange for them to become lessees or renters entitled to continue to reside in their own residence. And while Wheeler's defense is that he did not contact the Johnsons, they contacted him, it is nonetheless implicit in the complaint that Shepard, at all relevant times, was acting for or on behalf of Wheeler and or Wheeler Realty in soliciting the Johnsons. Therefore, even based on the Wheeler theory of defense, the Johnsons argue that a cause of action under their act has been properly stated against him. The court agrees that Wheeler and Wheeler Realty can be held in violation if Shepard is found to have acted as their agent or in some material respect on their behalf, and that the complaint fairly alleges that he so acted. So basically, what this means is that part of the complaint is that Wheeler acted as a foreclosure consultant because there are some things that he did that defined him as a foreclosure consultant. Wheeler's defense is that he's a real estate broker, and as a real estate broker he was supposed to be exempt. However, there's another thing that's at play here, and that is Mr. Shepard, who was a mortgage broker, and he too should also be exempt, but based on his actions is a foreclosure consultant. And even though he did not have a formal agency agreement with Wheeler, the bottom line is because of his actions, he was acting on Wheeler's behalf or as Wheeler's agent, and as such, because Mr. Shepard is a foreclosure consultant, so is Mr. Wheeler. Now, this pertains to the situation that we heard the foreclosure consultant talking about in the video clip, or I'm sorry, in the audio clip, where that foreclosure consultant was talking about acting on behalf of the buyer and making sure that the buyer is not saying anything or doing anything that would make him a foreclosure consultant. However, because the foreclosure consultant is a foreclosure consultant, and because that foreclosure consultant is working on behalf of the buyer, that then in turn makes the buyer a foreclosure consultant. In addition, the foreclosure consultant who was speaking does not have a license to broker real estate, and that is another thing that is required by the Protection of Homeowners and Foreclosure Act, that if you are going to participate in the sale of a residence in default or a residence in foreclosure, that you must be licensed as a real estate salesperson or a real estate broker. And this particular foreclosure consultant is not, even though implies in statement he or she is acting on behalf of the buyer. In addition, if the foreclosure consultant is not a real estate salesperson and doesn't believe that he or she is acting as a real estate salesperson, the argument could also be made that that particular individual is acting as an attorney, and I also have personal knowledge that that individual does not have a license to practice law in the state of Maryland either. So basically what this means is that anyone who is utilizing the services of that particular foreclosure consultant or other foreclosure consultants who are offering similar services, then in that situation the person who is buying the residence in foreclosure or the residence in default is actually a foreclosure consultant, and as such is prohibited from buying and could very easily end up running afoul of the law. And just for those of you who are not familiar, for violating the law, you are subject to 3 years imprisonment or a $10,000 fine, and that's per occurrence. And as we generally find with these laws, most people are breaking the law. If they do break the law, they're breaking it 3 and 4 times. And in fact, in the Johnson v. Wheeler case, we find that that it's more than 10 times that, or more than 10 counts that that are in the complaint against the defendants. As you can see, this law is not as simple as some like to think it is, and not everyone who calls himself or herself an expert is as well versed in this law as they should be. The penalties for getting it wrong include fines and punitive damages, as well as jail time. So be careful who you look to for advice. As for me, while I am recognized as an expert in the field, I really don't consider myself one. In my opinion, an X is a has-been, and a spurt is a drip under pressure. Instead, I like to surround myself with attorneys who are the brightest legal minds in the state of Maryland, so I don't have to have all the answers. Who you look to for advice is up to you. My suggestion is that you get the real facts from real professionals who know what they're doing. Simply go to www.drpreforeclosure.com to learn more. Again, that address is www.drpreforeclosure.com.